Now back to the show. This is AM 650's The Law Show.
We're talking personal injury law and medical malpractice today. Our guests, Joe Murphy, QC, and Angela Price-Stevens, are with Murphy Batista, LLP, a personal injury firm downtown at Georgia and Granville in Vancouver. Wanted to talk about, we've discussed some of the ways Murphy Batista does business and assesses clients and whether or not you're going to be able to take this case on and so on. I'm curious, though, because your firm is so well known and has such an excellent track record, do you, from time to time, end up, Angela, taking over a file that was started by another firm that, for whatever reason, the client has said, I think I'm going to get a second opinion or another lawyer? Does that happen?
Yes, it doesn't happen terribly often, probably 5-6 times a year.
Okay.
I'm approached. I don't always take the file, but it's not unusual to be approached by another lawyer's client, shall we say, who's perhaps not terribly happy. And one of the first things that I do, we're back to listening again, the art of listening. It's important. You listen to what the issues are according to the client. It may be that their perception, you can see through it a little bit and say, maybe the concern is that there's a delay. Well, you've obviously found out what the case is about, and you ask them. My practice is to say, well, have you raised these concerns with your existing lawyer? What was their reaction? And so I try to, what I'm doing is I'm trying to do the very best for the caller, even though they may not be my client. They're somebody else's client at this point. So I'm trying to figure out, okay, how can I mediate the situation? Ultimately, though, I will offer a second opinion. And that's when I perhaps will contact the other lawyer with the client's permission and just approach them and say, I've been asked to provide a second opinion. Could you give me certain key documents?
When you do that, by the way, and this is really inside stuff. This is why I love doing the law show. This is lawyer-to-lawyer stuff that we never get to know about.
Right.
If someone comes to you and says, I need you to take over my case, I'm unhappy with my lawyer, or the scenario as you've just described it, now you need some information based on the initial activity between that client and the first lawyer. Is that first lawyer obligated to send you every bit of paper that passed back and forth between that lawyer and that client in the first round?
Well, every single piece of paper that's all-encompassing. In the first instance, I am looking to just the information that I feel is key. Because what I don't want to do is to end up pulling that client to me and then finding that, the concerns are such that, you're actually better off, you're fine where you are. And that's actually happened more than once, where I've looked at the documents that the client has. Normally I try to do it without asking for documents from the other lawyer.
Sure, right.
And a few times that I've looked at maybe the mediation brief that's been prepared, some of the reports that are in the client's possession, and I'll look at them and say, you know what, I think maybe this is going to take a little bit longer than you had anticipated.
Sure.
I would suggest you go back and raise these concerns with your lawyer again. And then, of course, you have situations where you think, whoa, nothing's been done on this for a little while. Or maybe there's been a breakdown between the lawyer. There's just been a breakdown in relationship, and, like a marriage, it's not going to, you can't kiss and make up. So it's perhaps better for them to come elsewhere. And then I will contact the other lawyer. Now, yes, that lawyer has an obligation to do what's best for their client.
Okay. So there are rules in place.
There are rules in place. And, some clients feel that they maybe don't have the option to go elsewhere, or they're afraid because they feel there's going to be a financial burden.
Well, I was just going to say that we were talking about that during the break, Joe, about the fact that if you've retained a lawyer and you're already on the hook for Lord knows how much money because they've executed some paper on your behalf and so on. So now you've got a bit of a tab running with this person or that firm, but it's just not cutting it. They're not working out, and yet you've got an outstanding bill. So why would you go and run up a second tab with a second firm? It's all about economics instead of the priority, which is resolving this outstanding potential claim, right?
Yes, yes, Sterling, the average fee agreement between a client and a lawyer, and both of them sign it, says that if you move the file, you have to immediately pay me for the work I've done, and you
Right.
have to immediately pay me for the expenses I've incurred. And while the agreement says that, the law says that the client does not have to pay until the end of the case.
Oh.
So while most people stay with lawyers they may not be happy with because they read this contract and say, I could never afford to pay this now,
I was just going to say,
the
and
reality
it's
is,
a contract with a lawyer. This has got to be pretty tight. So,
oh yeah.
And it's not.
So the law says, no, you don't have to pay for that until the case is finished.
Now, aren't you glad you tuned into the Law Show this morning, friends? I mean, holy cow, who knew that, Joe? And
Well,
do lawyers get a little pushy on some of these matters? If you want to ditch a lawyer and he says, well, off you go. I mean, it's a free country, but you owe me, X number of $1,000, and I'd like to see that before you move along. You can move along anyway. You can say, you'll see that when I have a resolution to this case with someone I'm happy to work with.
well, most people read the agreement and realize they're stuck, but what they don't realize is that part of the agreement is not the law in BC.
Wow,
Our fee agreement doesn't have anything that says that. That's not the way we operate, to put in a clause into an agreement that we know isn't enforceable. That's just not the way we do things,
Right.
do business.
And yet that's kind of standard practice.
I think it's in most of the fee agreements in the other firms that I've read. In
Right.
fact, these agreements can go on for pages and pages, and just about every one of the clauses is for the benefit of the lawyer.
Right.
Our fee agreement is a page and a half long. It doesn't have all that stuff because, again, it's just it shouldn't be there in my mind. But I probably, of the cases that I take in, 1 in 4 will be from another lawyer. And it arises from a client realizing that they didn't make the best choice.
Right.
There are 2 sort of basic kinds of problems that prompt these people to move. Number 1 is they just can't deal with the lawyer, usually because the lawyer won't talk to them, doesn't phone them back, doesn't tell them what's going on. But commonly with really complicated injuries, such as a brain injury, a spinal cord injury, the lawyer that has the file doesn't have the experience with these injuries to
Right.
understanding what kind of evidence you have to put together to show the long-term impact, particularly with a brain injury. The first time I meet with a brain-injured client, if I say to them, how are you doing? It's almost invariable that they say, I'm doing well, I'm doing fine,
Sure.
doing good.
Mm-hmm.
That's what I expect them to say. And these are the people that often are the most disabled of any of my clients.
Right.
So if you take it at face value, you can really miss the impact. You have to understand what these injuries are about. Spinal cord injury. Most of the problems, if you have a spinal cord injury, are invisible to see.
Right.
The bowel, bladder, sexual problems, the systemic problems. You just see someone sitting in a wheelchair.
Sure. Sure.
And with just that, you're going to miss so much about what the impact of this injury is on their lives.
Okay.
So that's why some people, I think, end up coming to us, because they've got a lawyer who, through usually inexperience, just doesn't understand what this injury entails, and therefore doesn't understand the experts that have to be hired to write the reports to tell the whole story.
Some cases, Angela, are just beyond the capabilities of some lawyers, especially if they're not devoting the majority of their time at work to the practice of this type of law. If you've got a general practitioner and suddenly you've got a medical malpractice suit that's incredibly complex, maybe you've got the wrong lawyer on the case.
Yes, in a nutshell, a lawyer that finds themselves in that situation, it's almost like they don't know what they don't know. And so how do you bring somebody up to speed? You can't. It takes years of experience and the right background to be able to see some of the pitfalls. Never mind all of the pitfalls. You have to have the full range of experience. You need to be in a firm with deep pockets. You're up against a very challenging opposition. You cannot afford to skimp on anything.
Is it sorry to interrupt, but is it, because we need to take a break and Dwayne's having kittens in the other room, so we better put him out of his misery, but is it safe to say to the two of you that if you're going to take on a doctor, if you're going to sue a doctor anywhere in Canada, you are going to go up against likely some of the very best lawyers the country has?
In a word, yes.
the docs take pretty good care of themselves.
Oh, absolutely, yes.
CMPA does a great job for its doctors, and if I was a doctor, I would want that kind of protection.
So if you are contemplating, for whatever reason, a medical malpractice circumstance, make sure you deal with professionals like our friends at Murphy Batista, because it's going to take that level of quality lawyering on your side to go up against the formidable forces that the doctors of Canada can array across the field from you. We'll take that all-important break and come back with lots more on The Law Show after this.
This is AM 650's The Law Show. There's more of the show still ahead.